Hi, my name is Schyler Church. I am a California real estate broker as well as a member of the education department at Accredited Real Estate Schools. We offer the course requirements to be eligible to take the state exam, as well as varying levels of preparation. And here we're going to be talking about Jeopardy. So something to help you review for that state exam to see how proficient you are with the material. So let's dive on in and get to it. So here are our categories: fee simple, agency, appraisal, amortization, disclosures and reports, and then contracts. And just know I'm going to go at this at a pretty steady but fast pace, so feel free to always pause once you see the answer, as it's Jeopardy, remember, to come up with the question. But let's dive in. So fee simple 1. This is another name for an estate of inheritance. Okay, so let's see here, an estate of inheritance. Well, you should be automatically thinking on the freehold estate side. Which one is an estate of inheritance? It's also called an estate in fee. Estate in fee. So this is a fee simple estate. Just this is the technical name. 2. Fee simple estate refers to the greatest this a person can own in land. When we're talking about fee simple estates, you have the entire bundle of rights. So you have the greatest interest a person can own in land with either fee simple absolute or fee simple defeasible. 3. This is the distinguishing feature of a fee simple estate. Not a distinguishing feature, but the distinguishing feature. What really sets a fee simple estate apart from the other freehold estate of a life estate? Well, the biggest difference is that a fee simple estate is also allowed to be an estate of inheritance, which means it can be willed. You're able to devise your property. You're able to leave it to your heirs. And that's the distinguishing feature of a fee simple estate. You know, another distinguishing feature, but a distinguishing feature, is that it is freely transferable, a fee simple estate, but the distinguishing one is that it can be willed or devised. 4. A property has the entire bundle of rights without any restrictions. The owner holds this title to the property. Okay, so what we know is that we have fee simple is the greatest interest, where you have the entire bundle of rights. But under fee simple, and you don't have any restrictions, which one is that? Fee simple absolute. 5. A buyer agrees not to sell alcoholic beverages on the property being acquired. This fact is noted in the deed granting buyer title to the property. The buyer has taken this title to the property. So the buyer has taken this title to the property. We pretty much can infer that it has been, that he has all the bundle of rights, but with this restriction that he cannot sell alcoholic beverages. And if he does do so, then the title can be defeated. And what does this make you think of? Fee simple defeasible title to the property. Agency 1. The relationship between principal and agent is called this type of obligation. So we're talking about agency here, and when that is created between a principal and an agent, we have a fiduciary obligation. Fiduciary. Agency 2. An agency relationship is best established by this. So what is the best way to create a relationship or even have any type of agreement created? The best way is through written agreement. So this might be an express agreement, either written or in words, or oral, for instance, but a written one that's actually written down is the best way to create an agency relationship. And it's the best way for any type of agreement as well. Agency 3. A salesperson's listings are the property of this person or entity. Okay, so remember, in California, a real estate salesperson must be under a real estate broker. So even though the salesperson might be the direct point of contact with the listing, the actual listing is owned by the salesperson's broker. So the real estate broker that actually is the one supervising the real estate salesperson, because remember, the broker is the agent in the relationship with the principal and the salesperson is the sub-agent. Agency 4. Agency by this occurs when a person acts as the agent for a principal without a written authorization to do so, and the principal accepts, ratifies the agent's actions. Okay, so we kind of gave it away in this, but what do we call this? Agency by this occurs when a person acts as the agent for a principal, and so he's acting on it, but without written authorization to do so. But the principal does accept that the agent's actions. So the agency is created by ratification. The principal is ratifying the agent's actions and allowing the agent to act as basically their agent, even though there is not a written authorization to do so. So as always, though, the best way to create an agency relationship is by written agreement, but you can create agency by oral agreement. It can also be by implied, so by your implied actions, for instance. So we have ostensible authority, and it can also be through ratification, which we're talking about now. Agency 5. If a broker who solicits and accepts a deposit on the purchase of a parcel of real property without express written authorization from the owner to sell the property, he is acting as agent for this person. So if an agent is accepting a deposit on a purchase of a parcel of real property, but he doesn't have the actual authorization from the seller or even the owner of the property to sell the property, the agent is accepting the deposit on behalf of the buyer. So that's important to know, the buyer. Appraisal 1. When an appraiser begins to determine the value of a residential property, he or she will consider this. So we first always are going to be defining the problem, figuring out what the appraisal is for. But we know that it's been the biggest thing. But when they're trying to determine the value of the residential property, the first thing that the appraiser is going to be looking at is the marketability and acceptability of the property. Appraisal 2. Terms and conditions of the sale of a specific parcel of real property would generally affect this of the subject property. So the sale of a specific parcel of real property will usually be of the subject property is usually going to be affected by the terms and conditions when it comes to the price. So actually the price that is going to be agreed upon between the buyer and the seller. Terms and conditions are going to be a big thing. For instance, let's say somebody might be able to close in 10 days with an all-cash offer. The seller may be willing to accept a lower price than somebody that's going to pay more, but it might be a 60 to 90-day escrow. Or for instance, there might be more contingencies. So the price is usually always going to be the one that is affected by the terms and conditions of the sale. Appraisal 3. The most probable price the property should bring on the open market is called this. So the price that the property will actually bring on the open market, where a buyer is willing to purchase it and the seller is willing to sell it, this probable price is called the market value. The market value of what would actually happen on the market. Of course, there could be, it could sell for more if you just find the right buyer. It could sell for less because maybe there's just something unexplained about you can't explain it, and it's just not selling for as much. So, but the most probable price is the market value when it's on the open market. Appraisal 4. External issues outside the property line is called this. So remember, external issues, so we're talking about a depreciation of a loss in value, and when it's outside the property lines, it's called economic obsolescence. If it was within the property line, due to, for instance, styling issues, that would be functional obsolescence. Or if within the property line, the property is just showing wear and tear, then that would be physical deterioration. Appraisal 5. The appraiser determines that the building on a parcel of real property adds no value to the land. Considering the highest and best use for the property and determining value, the appraiser would do this. So the appraiser looks at the property and realizes that the building on that property is actually not adding any value, but the land itself is invaluable to it. So looking at the highest and best use of the property to determine this value, the appraiser is going to value it for the land value, but also subtract what it would be to basically demolish the building. So subtract the cost of the demolition of the building from the value of the land. Amortization 1. The liquidation of a financial obligation on an installment plan or basis is referred to as this. So the liquidation of a financial obligation in an installment plan or basis is referred to as this. This is just a technical way of saying amortization. We have that in the category, so it should be easy to know, but this is just the technical way of explaining amortization. Is you're looking at your financial obligations, like your debt, and you're paying it off on a regular basis, and that is through something we call amortization. Amortization 2. A loan that is completely repaid by a series of regular equal installment payments on principal and interest is called this type of loan. Okay, what type of loan repays it in a series of regular and equal payments? So the payment doesn't really vary on the price and you're paying in principal and interest. This is a fully amortized loan. Remember, on a fully amortized loan, the actual payment that you're paying in the beginning will be mostly interest, and then you'll be paying a little bit of principal. But as time goes on, that curve changes and you're going to be paying more principal and less interest. And that's in the actual payments. But remember, on a fully amortized loan, you are paying the principal down as you go. But remember, the lender is going to want to collect as much interest in the beginning, so that's why the payment is going to be mostly interest towards the beginning of the loan. Amortization 3. A balloon payment is a part of this. Okay, so when you hear balloon payment, you should be thinking of what type of amortized loan? A partially amortized loan. So a partially amortized loan is just like a fully amortized loan. It has the same schedule and that curve, that amortization curve we look at, but it'll become due and payable, let's say 5 or 7 years after it starts, even though it's amortized on a 30-year schedule. And what we call is this lump sum payment that you're going to be paying at that 5 or 7 year mark is a balloon payment. And that is associated with this partially amortized loan. Amortization 4. A loan in which the required monthly payment is not sufficient to cover the monthly interest that is due is known as this. So you're paying for your loan to go down, but you're actually not having the balance, the principal balance that is due going down because you're barely covering enough of the principal, but you're not covering enough of the interest. So that's actually going to compound onto the loan. So you're actually going to have to owe more as time goes on. So negative amortization doesn't even cover your enough for the actual payment or the actual amount of the loan balance to decrease. Amortization 5. The amount applied to principal increases while the interest payment decreases by a constant amount when a loan is this by equal monthly payments of principal and interest. Okay, so the amount applied to principal increases while the interest payment decreases by a constant amount when a loan is this by equal monthly payments of principal and interest. Well, let's see here. When it's fully amortized. Okay, so what we're saying here is that what we've kind of talked about earlier is that the principal amount that you're paying in the actual payment will be increasing. So let's say you're paying $1,000 a month in the beginning of a fully amortized loan. You're going to be paying, let's say, the bulk of it is going to be going towards the interest and only a slight portion of it will be going to the principal. Whereas if you had down the road, maybe 7, 8 years, 10 years down the road, depending if, let's say, it's a 30-year amortized loan, or if it's a 30-year amortized loan, you're actually going to be, let's say, at the 29th year, most of your payment is going to be going towards the principal amount, and very little will be going towards the interest. And so when a loan is fully amortized by equal monthly payments of principal and interest, the amount applied to principal increases while the interest payment decreases. Disclosures and reports 1. A single-family residence in contract as is required to provide this disclosure. So remember, in California, if you have a single-family residence in contract, you are required, with few exceptions, but to provide a transfer disclosure statement, which is just called a real property disclosure statement, so aka that TDS. Even if the property is as is, where the seller is saying, I'm not going to do any work, if it's a single-family residence and the seller does not fall onto the exemptions, for instance, if it is a foreclosure or there's so many other things, but foreclosure is the most important one you need to know for the state exam. Even if the seller is not going to be making repairs, a single-family residence in contract, the seller must provide a real property disclosure statement, so that TDS. Disclosures and reports 2. A real estate transfer disclosure statement need not be prepared for an apartment complex with this minimum of units. So remember, in California, we have to do a real estate transfer disclosure statement per the Civil Code, and that has to be provided for properties, residential properties of 1 to 4 units. So if an apartment complex is 5 or more units, a real estate transfer disclosure statement is not required. And then disclosures and reports 3. A person sells his or her home. During escrow, a termite inspection is made and a report written. If all the recommended work is completed before close of escrow, the seller must give a copy of the report to the buyer by this time. Remember, these reports need to be provided as soon as practicable, or possible. So it needs to be provided as soon as possible. Disclosures and reports 4. A single-family residence in contract as is required to provide this disclosure. Well, apparently I already put this in there, but I think it's important. So you should know this by now. What is that most important disclosure called? That transfer disclosure statement has to be provided to 1 to 4 unit properties. And then as long as you don't fall within that exemption, and it needs to be provided even if you're selling it as is. Disclosures and reports 5. On the real estate transfer disclosure statement form, the broker must do this. What does the broker need to do on that TDS? They need to make a competent and diligent visual inspection of accessible areas and report the findings on the form. So us as agents need to do a diligent visual inspection of accessible areas. So if it was, you don't need to be crawling under the foundation of the home in the crawl space, for instance, but you need to do all accessible areas. You need to make a visual inspection and note your findings on the report note your findings on this TDS form. Contracts 1. An express contract is a contract where the parties put their intentions and the terms of the agreement in this type of form. So an express contract, what you should automatically be thinking of is it's a contract in words. It can be written or oral, but it must be in words for an express contract. The best way, though, is always to have it in written form. Contracts 2. The term voidable contract refers to a contract that is valid until this happens. So if a contract is voidable, so for instance, there is a certain condition that makes the contract valid, but if upon the event of this, it's voidable. So it's valid until the contract is rescinded. Contracts 3. A contract signed under duress is considered this. So we were just talking about a voidable contract. Well, let's just say a voidable contract is one that is signed under duress, because that is true. A contract signed under duress is considered voidable. And what we're talking about here is, so if you, for instance, somebody held you against your will and they said, you have to sign this contract. Well, that contract is valid because you did sign it, but it is considered a voidable contract until you actually rescind it. So if you did want to sign it, even though you were under duress, it can be a valid contract. But if you didn't actually want to sign it, then you could rescind it and that is because it is a voidable contract. Contracts 4. It means this when a contract has been executed. Well, what does it mean when a contract has been executed? Well, all the terms and conditions have been met and the parties have performed and completed their obligations as provided by the contract. Contracts 5. These are necessary elements of a contract. So we're not necessarily saying a real estate contract, but a contract, any type of contract. What are the 4 necessary elements? Okay, the 4 that we should talk about here are the capacity to contract. So remember, you have to have not been declared incompetent in a court of law. You can't be a minor, for instance. But there are those exceptions you should know. Consideration, so anything of value does not need to be money, but it could be a service, an act of forbearance, something of value. Legality, so it must be of legal purpose. And mutual consent or mutual assent, so a genuine offer and genuine acceptance. These are the necessary elements of a contract. But a real estate contract also has something called the statute of frauds that requires real estate contracts to be in writing. The only exception to that is our leases of a year or less. Those do not need to be in writing, as well as any type of contract that takes over a year to perform. Then the statute of frauds also applies and it needs to be in writing. So I know we just covered a lot. I hope this was helpful. If you have any questions, please feel free to contact us and make sure to check out Accredited. We have a lot of exam preparation options to make sure you're prepared, from video to live classes to practice questions. We service just California. That's all we do, and we're really good at it, honestly. So thanks for watching, and I hope you have a great rest of your day.